Hello and welcome to week 7 of DMCA 301. The topic this week is copyright law and digital marketing. Copyright law in the U.S. is governed by federal statute, namely the Copyright Act of 1976. The Copyright Act prevents the unauthorized copying of a work of authorship. However, only copying of the work is prohibited. Anyone may copy the ideas contained within a work in the usual course of business. Overall, copyright law means you can't just verbatim take and plagiarize someone else's work. That could be copy, that could be content, especially in a digital marketing perspective. You can't just plagiarize someone else's overall content. However, though, you can be influenced by it or quote it in certain instances. It's definitely important in digital marketing too to understand intellectual property, trademarks, and other types of laws that exist where you can't just take someone else's overall branding and elements of how they market their products and services. One key area this influences in digital marketing is an imagery. Imagery is a key cornerstone and context for how we communicate and influence our customers in digital marketing. There are 3 types of overall copyright law and imagery things to keep in mind. First, a public domain. Images in the public domain are free for anyone to use as they wish. This includes any photograph created by the U.S. government and others. There are a wealth of free and obtainable resource images out there in the public domain. This means it is allowed to be used without any major copyright law influence. However, it's very important for a digital marketer and an organization to ensure they know the source, to ensure it truly is a public domain. There's also the GNU public license. A GNU public license, or GPL, is a very extensive license, but essentially means you are free to use and edit the image as you wish on the condition it is released on the same license and the license it's mentioned. A GPL therefore may not be suitable for business blogs and websites, but could be useful for many others. This means you're allowed to reuse something in the condition that it is overall in the same license and there's also a mention of it. However, though, for blogs and websites, just copying and pasting an image under the GNU public license isn't enough. Usually, you need authorization from the source and the owner of that image. There's also the Creative Commons. The Creative Commons license is one of the most popular online and will usually be labeled as such with a CC. Creators who wish to release their images under a CC license can apply layers, which permits people to use the image on certain conditions. Perhaps it requires credit or it's only for non-commercial use. It could also restrict editing. What this means is that it's very particular and when it's used. If it's for overall purposes of generating non-commercial content, perhaps for some type of, especially non-profit organization, they can generally leverage this. If it's for marketing other elements, perhaps CSR, marketing campaigns, this may be another area. Within each of these, though, there are elements of how you can and cannot use imagery in digital marketing. It's very important to understand the source and comply with those overall parameters. What really affects digital marketing is something called the Digital Millennium Copyright Act. If your website or mobile app allows users from the United States to post content, you need to be in compliance with the DMCA, or the Digital Millennium Copyright Act. The DMCA is an American law that aims to protect digital media from copyright infringement. It includes a DMCA notice in your terms and conditions or terms of service agreement. This notice should let users know that you have adopted a policy towards copyright infringement in accordance with the DMCA. It includes a process where users can submit takedown requests if they believe something posted on your website or app is infringing upon a copyright. What this means is that you are working on indemnification, that you are working within the confines of the imagery that you're using and the digital content. But if for some reason a user out there believes that it's copyright content, they have a way to contact the organization directly with a very clear address, phone number, and means to be contacted. So therefore the user can request that content be taken down if it doesn't comply, if it violates their copyright law. And if their content is copyrighted, companies must oblige by that and remove that content from websites. As fast-paced as websites are being built and updated and modified with a number of websites out there and blogs and even social media content, digital at times is a challenge for digital marketers to understand truly what is copyrighted or not. it is important to look at that. And it's important for owners of content to copyright their product, their digital product, to overall ensure that the overall the label of copyright is on their work. Without that, it is hard for websites and digital marketers to understand what is copyrighted or not. However, under the DMCA, if there is copyrighted content you're using, you have to remove it in the time that a user finds it and qualifies for that removal. So in general, digital marketing has to make sure that their copyright law parameters are intact, that there's a review process from a creative and content creation perspective, and that we're in compliance. Thanks for your time, and I hope you enjoyed this lecture.